why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think compel what I've just suggested should happen. We noted in our reply brief that the county attorney should not be representing themselves. And that's probably an inadequate message to the court. But we did file a motion to disqualify. And inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial authority, which, as I've done further research, and Mr. Bird and Ms. Visser and Ms. Nestor and I have all done further research, literally up until earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword. If the court thinks I should be sanctioned for not bringing this up sooner, I hear the court. But we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not aware of. But the court can imagine.
No, and I appreciate that. It's not the intent to sanction you. I understand that issues come up, and there's a lot going on. And so the court appreciates your candor and representation today. So these items can evolve. And so the court is not finding fault with you. It's just hoping that as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties, we just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
That's right. And also for Mr. Robinson himself and the victim representative, Ms. Kirk as well. We just want to do our best, and I understand. And I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happened, so I understand. I'll turn to the state. Oh, and I'm sorry. Is there anything further that you wish to represent?
No, I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think with all consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way once we understood not only the way this was developing, but frankly the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now if you'd like to list them. The court is ready.
So the second one would be State v. Robertson, and that is also a Utah case, 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any Utah rule on point that addresses this issue?
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Okay. Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course. Right. Thank you. Turning to the state, Mr. Gray.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them more than a week ago, I don't know why they wouldn't at least notify the court. I, too, represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic to delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too? I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
Yeah,
Mr. McBride.
and excuse me, this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts from the few minutes I've had to read those cases. I do want to state, this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case, but in the alternative says, we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion, or memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion, or the request that the defense has made, assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
There is one other point I wanted to make, which is the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed. That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or alleging conflicts. There's a lot of case law that talks about how it can be a tactic to try and remove cases from one prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to seek, for example, in this case, the death penalty. And there's a lot of case law that talks about you can't call opposing counsel as a witness in a case unless they're absolutely necessary. And the reason is because it can be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled, you allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Your Honor, we're ready to go forward today. We think the evidence that will be presented today will illuminate the issues adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the filing of a motion addressing more fully this issue. And to that request, what is the state's reply?
We object to that motion to continue or to strike. We ask the court to go forward today. We think the motion is untimely. The prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed. These people are ready to move forward and get this out of the way. The longer we delay this, the more anxiety that this procedure has.
All right, thank you, Mr. McBride. To defense, any response?
Yes, John, thank you. First, I want to say this is not about seeking a lenient prosecutor. This is not about tactics at all. And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present at Utah Valley University at the Charlie Kirk rally and experienced and witnessed certain things. We didn't make this up out of whole cloth. We didn't grab onto some piece of discovery and say, a wedge, a tactic. The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out of whole cloth because, like I said, we found a needle in a haystack. It's something that they properly brought to our attention, but we firmly believe that the law supports the conclusion that that particular prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way, and there was no effort to screen off that prosecutor, and that has now created a problem for the whole office. That is not made up out of whole cloth, and like I said, it's not about tactics or lenience or delay. This isn't delaying anything, at least on our part. The other thing that I want to point out is to say that until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict is to at least temporarily have the Attorney General's office handle this. Yes, Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A judicial officer decides to become a prosecutor. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from, as Your Honor knows. A defense attorney changes careers and becomes a prosecutor. There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack, it's not a tactic, it's not a fiction, it's not a thin reed. The evidence that the court has suggests, number one, that there's a very good possibility that as a legal matter there's a conflict of interest. That's why we need to have an evidentiary hearing, because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on, without consulting with anybody, that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend the decisions that they've made, but the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right?